Good afternoon, everybody, and welcome to today's presentation of the 2018 California Employment Laws, What You Need to Know. Before we get started, I want to inform everybody that you are placed on mute, so it's to reduce the level of background noise so that there's less interruption during the presentation. Also, the webinar is being recorded, so, understand that if somebody's not able to watch it, they are able to go back later on and watch the presentation at their leisure. Because of time constraints and the number of people that are going to be on and likely ask questions today, questions will not be fielded during the presentation. They will be recorded. So if you look on the dashboard there, you have the question field. I highly encourage you to type in your questions at any point in time, and they will be forwarded to today's presenters to be answered in full, where they'll generate probably a list of questions with answers, and it'll be redistributed to everybody who attends today. So please ask your questions anytime throughout. And with that, I'm going to go ahead and turn it over to our presenters, Michael Chick and Leanne Ciccarelli.
Good day, everybody. This is Michael Chick. I am the manager of HR Field Services for Oasis Outsourcing, and I have been in human resources for over 30 years and in California for almost that long. So I have a long history with California employment laws and how to execute strategies given the laws so that you can make sure to stay on the right side of our employment laws. And my fellow presenter, who's going to be doing the bulk of the presentation today, is Leanne Ciccarelli. And Leanne is part of our Oasis legal team. She's our labor and employment counsel. And Leanne has been in the business for doing labor law for over 20 years and is, a very highly qualified expert that has a lot of knowledge. So with that, she and I are going to share the time. She's going to be doing most of the presentation, but I will be coming in talking about action steps for you. So with that, I'm going to go ahead and turn it over to Leanne.
Great. Thanks, Michael. And as Michael said, there's a lot to cover today, too, so we're going to jump right in. Lots going on in California, and for the constraints of time, we're just going to jump into the first one and get going. And again, lots of questions are sure to follow. As with most laws, when they first come out, not everything's answered, so there's going to be open questions. But there are some, obviously, we can address along the way, so please submit those questions. That being said, let's jump right into the first law, effective Jan 1 of 2018 in California, would be the statewide ban the box bill. The existing California law, there is already a ban the box, but that applies just to state and local agencies. This now extends the ban the box provisions to employers with 5 or more employees, so basically all employers in California. For those of you that do business in other states, many other states have moved to a ban the box, so it's nothing particularly new and novel, but it is important that it now extends down to employers with just 5 or more employees. So what does that effectively mean? No criminal history questions on the application. The only time you can start asking about criminal history is in a post-conditional offer situation. And even then, that requires an individualized assessment. So if you do start asking the questions post-offer and you get a response back, you then need to assess certain things, including the nature and gravity of the offense of the conduct, the time that has passed since the conduct occurred or the offense has been completed, as well as the nature of the job held or sought. So basically, consideration of anything beyond 7 years old is going to be considered unlawful. So even when you get to that, if you make that preliminary decision based on those factors, the nature and gravity and the time passed and the job held, there is now also this fair chance process before you can take an adverse action to not move forward with that applicant. So that's new and something to be aware of. That fair chance process requires a written notice to that applicant, including a copy of the history, the conviction history, as well as a right to respond. You have to give them 5 business days to respond to that notice. And during that 5 days, you can't make a final determination about that applicant. And if they do timely notify you that they're disputing the conviction, they actually get 5 more days or you have 5 days to respond back to that. And you have to consider any additional evidence they may have given you. So again, there's a process here that you have to go through that would be new. If the employer, if you ultimately decide to deny that applicant, you then have to notify them again in writing that you're taking that decision. So multiple steps now apply. There will continue to be, as in most other states with similar ban the box initiatives, exceptions for certain employment situations where a background check is required by law. That includes state or local agencies that require it, positioned with the criminal justice agency, for example. It also excludes farm labor contractors, some very limited exceptions where this does not apply. But generally speaking, that is ban the box. Michael, turn to you for some action steps.
Okay, great. So what do we do about that? So these are the steps that we recommend all employers take a look at in terms of managing these new laws and making sure that you're being compliant. So the first one is review your employment application forms. All the forms that you use going forward should not include questions prohibited by this new law. And now for all of our Oasis clients, we actually have a compliant sample application, and it is available on your Oasis Client Services website. So if you just type in application into your search box where you've got forms, what should pop up should be an application that you use that is compliant. The second thing that you should do is review your hiring process and the timing of your inquiry into criminal records. Again, because this law is very specific about the process that you have to use, you need to be sure that if you are doing any kind of inquiry into criminal background, that it's done at the appropriate time. So you need to look at your processes to make sure you're following the steps of the law. A third action step you should consider is to revise and review background check procedures and incorporate that individual assessment and appropriate steps before you take adverse action. So again, it was quite detailed about how they want you to go about considering that kind of background for somebody, once it's uncovered. So you need to make sure that your processes and procedures incorporate all those individual assessments into your process before you take any action. And then the last one is pretty obvious. You want to train your hiring managers. So everybody that is involved in your hiring process that may be able to take a look at an applicant and make a decision, they need to be sure that they're trained on this process and that they're doing that correctly. Okay, next slide.
Great. So the next up is AB 168. It's a salary history bill, again, effective Jan 1. These are all effective Jan 1. This really continues the expansion of the Equal Pay Protection Act in California that's been on the books since 1949. There was a 2016 revision to that law that amended the previous act to basically require equal pay for substantially similar work. And it currently requires that you can't use prior salary to justify the current disparity in your pay. Well, now the law is expanding further to expand the equal pay protection, and it prohibits the inquiries into the applicant's salary history. Reason behind that, the theory behind that, is that it's to no longer perpetuate pay inequities that may have occurred in the past and may have been discriminatory. So now you can't directly or indirectly, so not through a recruiter, you can't ask about their salary history. It includes benefits and all compensation in order to make a decision about their pay. The applicant can voluntarily disclose, and in which case, obviously, the employer is not prohibited from considering or using that. However, be mindful that there's still going to be the equal pay issue, so be careful not to perpetuate any pay inequalities. If an applicant asks for the pay scale for a position, the employer must provide it. And I mean, obviously, if you don't have that published, that could be an interesting question, but you would want to have that pay scale available. So
Hello?
I think we might have lost Leanne, Michael. Michael?
Okay, well, okay, so let me go ahead and do action steps, and we'll see if we can get Leanne back on the line. So what do we do about this? So the first thing that we want to do is we want to make sure they're review and revise your job applications and look at all the forms that you have to make sure that you comply with the new restrictions. And again, there's a sample application on the client services website. Our application does not have any questions about salary history on it. So if you use that, you'll be sure to be in compliance. The second step is to train anyone involved in the hiring process about the impact of the new law. And speaking as a longtime HR practitioner, this is definitely going to involve changing your strategies many times in terms of how you're looking at people. So, one of the things I know is, having done this for many years is, one would tend to take this old history of someone who's coming in, apply a percentage to that, and say, we're going to give a 10 to 15% up from where you are, and that's our initial offer. Those are the kind of practices that you're going to have to cease and desist on, and you're really going to need to be basing your the decision on what to pay for an applicant strictly on, here's the position, here's the range we have in the position, and we need to be paying in that range. So, many of you may already be doing that, but if you do have some of those old practices in place from before about considering, well, I'm only give X amount of percent of increase from where they were before, those are the kind of practices that you're going to have to stop and reconsider how you do that. Also, as part of it, you want to make sure this may now start to have some compression issues. So you'll also want to begin to take a look at your whole workforce and say, given that I have to do this now for new people, what are the impact on the people I currently have on my payroll, and make sure you're doing that analysis as well. So Leanne, is Leanne back?
I'm back. Can you hear me now?
Okay, there we go.
There we go. Okay, somehow I got booted off, but hopefully it didn't cut out too much. All right. So jumping into the next would be Senate Bill 306 was retaliation. We have one slide dedicated to this bill, but it's actually a big one in how it's going to impact employers in California. So as we all know, in recent years, we've seen a lot of retaliation claims. This is just yet another avenue now for employees. It's a very employee-friendly bill to pursue retaliation. So currently, the labor commissioner can seek injunctive relief, meaning they can seek to make the employer do something if they think that that an adverse action has been taken. If they've completed an investigation and they think some action needs to be taken. Now it moves it up. The labor commissioner in a pending claim can authorize injunctive relief and seek injunctive relief in retaliation cases. Essentially, this means employers are forced to put an employee back to work while a claim is pending and being resolved, which can take years. So it really bumps up the game. And most importantly, too, on the injunctive relief side, and not to get too technical, but it also lowers the burden of proof in getting injunctive relief. If anybody has experience in this area, you know that injunctive relief is a pretty high burden. You have to show the success on the merits and all this other great stuff. Now, basically, if they can show that there's reasonable cause to believe an employee has been unlawfully discharged or subject to an adverse action, they can get injunctive relief asking to put that employee back in the workplace pending the claim. So it also, some other important parts too, if they go through those steps, the labor commissioner, not only can they petition the court for the reinstatement, they can get their attorney's fees. Employees can do this on themselves through litigation, through their own lawyer, but the labor commissioner can step in as well. Also, the existing law right now authorizes certain investigations only when an employee files a complaint, but the labor commissioner can now proceed on their own without a complaint if it's suspected that retaliation has occurred or during a field inspection or anything similar to that. There's some avenues where they have basically just a little more power to go through and start looking at these issues. So, as we know, as a practical matter, a lot of times employees that sense something's going to happen, that they're going to be terminated or disciplined for attendance issues or poor performance, they'll often run to file a claim to sort of protect themselves from an adverse employment action. This just sort of upped the game in that sense, because if they go and file their claim and they can seek this injunctive relief to be put back in the workplace, it's just going to make it really hard to take any additional action against that employee, even if they are still behaving badly, because it's going to be deemed related to the pending claim. So be very mindful that retaliation just got a little stickier under SB 306. So action steps.
Once again, you want to take a look at your policies and review and revise them if necessary. If you do not have policies on whistleblowing or anti-retaliation policies, you should make sure to work with Oasis to get those things included. They are included as part of our handbooks, but in case you're fairly new, you want to make sure that those policies are up to speed. The second thing you want to do is really analyze and document disciplinary decisions. And now in HR, this is an obvious and something that you want to do all the time. But when you're taking a look at your standards of conduct, harassment, your whistleblower standards, making decisions about someone's activity and documenting that appropriately is going to become even more important now. Whistleblower and retaliation claims are one of the fastest growing claims that are happening around the country. And so, there's a lot of focus and visibility on those. So you want to make sure that you're documenting your decisions. And then once again, and this is kind of going to be similar for lots of these, you want to be sure that you're training your supervision and your managers and training your HR employees on what these laws mean, how you adjudicate them inside your organization, and to make sure that everybody is very aware of what's going on.
Absolutely. All right. Next on the list is AB 450. This one impacts immigration. It basically imposes new immigration-related duties on California employers. This is going to raise lots of questions of where do your state and federal obligations begin and end. You have the federal laws still exist, but this is an overlay now of what you need to do in California. In short, basically, you can't waive your Fourth Amendment right for search and seizure. So, to put it into context, historically, when ICE comes around, we've worked with clients and said, it's better to be cooperative, let them in, give them what they ask for. Under the California law, you cannot do that. It doesn't apply to the NOI, or their right to see the I-9s as it relates to that NOI, but you have to demand now a judicial warrant or subpoena before you would grant them access to the work site, so a search of the work site or a search of other employee records. So yes, they get the I-9s, but you basically cannot voluntarily consent to allowing that agent to enter non-public areas of a place of employment unless they give you that warrant or subpoena. So you can't just be cooperative anymore. So you see where your state and federal get a little interesting here. Again, though, too, just as a practical matter, because you do have to provide the I-9 still, this is, again, as a note, why we've always generally recommended keeping your I-9 separate. It makes it easier to comply with the I-9 without having to take the time to separate because you cannot allow them access to the other worksite records right away. So be mindful of that, just on practically how you're going to comply. Other notes about AB 450, if you get that advance notice of an ICE inspection, you also now have to give written notice of that inspection to employees. So you get the NOI, you have to basically post it, and it has to be in a language ordinarily used to communicate. So in California, that can be lots of different languages, so that can create some practical concerns about the posting if you do receive a notice of inspection. And it has to be posted within 74 hours of getting the notice, and it has to be also given to employee representatives. Obviously, if you're in a union environment, that means to the union reps. You also have to post the results of the inspection. So, they come in, they ask for your I-9s, you give it to them, and from that, you get the results. Any affected employee must then be given additional notice within 72 hours again, and that has to include basically all the deficiencies, the time period for correcting, time and date to meet with the employer, as well as their right to have representation present. So again, it really steps up your notice requirement on the state side. Also very interesting, the law prohibits an employer from re-verifying a current employee's employment eligibility at a time or in a manner not required under federal law. The open item here is that, this really raises questions about an employer's ability to do a self-audit. On the Fed side, they always encourage, that self-audit where you can purple pen and correct certain mistakes. The state law seems contrary to that because that's not required under federal law. It's just a suggestion and it's encouraged. So be mindful that might be impacted. We will obviously look for further guidance on that or some practical notes, but that is how it's written. Any violation of this law is punishable by a civil penalty between $2,000 and $10,000. And then it's basically each violation of a re-verification process can result in a penalty of up to $10,000 as well. So lots of penalties under this particular law. Again, compare that to the federal law as well. So lots of questions about how these two will play out together from the federal and the state side. Action steps.
So for our action steps, once again, you want to review your policies and procedures for verifying an employee's employment authorization. You want to be very careful that when you're doing I-9s and the people that are getting them from people really understand how to do that properly. Leanne also mentioned something very briefly when she was speaking. If you have not already, you really should consider having your I-9s be in separate files because again, that just makes it a lot easier. If someone does come in for an audit, that you have those files separate from everything else, and then that doesn't allow them access into any other files or any other areas of the company. You want to review and revise your procedures for immigration and agent inspections if that were to occur. And again, as always, train your staff on the law's requirements.
Great. So next up is SB 396, anti-discrimination. So as you know, or if most California employers already know, the Fair Employment and Housing Act requires employers with 50 or more employees to provide at least 2 hours of sexual harassment training and education to all supervisory employees within 6 months of their assumption of that supervisory position and once every 2 years. This new law requires those covered employers to include as a component of that training and education. It has to include training based on gender identity, gender expression, and sexual orientation. So it's just expanding what has to be included in the training. That training, as with the existing training requirements, it has to include practical examples of harassment based on gender identity, expression, and sexual orientation. And it also still must be presented by trainers or educators with knowledge and experience or expertise in those specific areas. The new law also requires the covered employers to post a notice to be developed. It hasn't been developed yet, but it's this posting requirement regarding transgender rights, the rights itself as opposed to the training requirement. The posting applies to employers with only 5 or more employees. Action steps.
So, once again, you want to review your training process and make sure that you're complying with the requirements to get your supervisors and managers training every 2 years. Oasis offers harassment training for all of our clients. We have multiple ways to get them. You can have it be online so that someone can take it at their own pace, and our online course is California compliant. We have webinars that are offered, I believe now, every other month, where you can come in and receive harassment training through a webinar. And then in cases of larger clients or whatever, we also have the ability to have that on site. So we have lots of ways for you to get training to your people at the company. And then the last thing, of course, once the notice is available, you'll need to post it. And so everyone's sure about this, all the notices that you typically get, everyone has the posters that have, all the laws, and you stick them, in the break room. Once the transgender information comes out, that's either you're going to have to change and get a new poster that has that included, or you're going to have to post a separate notice alongside the big notice that you have everywhere. So just know that that's something that's going to be coming. But again, as Leanne said, that has not been made available yet to the public. So as soon as it is, Oasis will have a posting notice available for you to use.
Next up is AB 1710, which is anti-discrimination protections for military. USERRA, the federal law, already prohibits discrimination in the terms, conditions, or privileges of employment against a person on the basis of either their past military service, their current military obligations, or their intent to serve. This new law basically amends the California Military and Veterans Code to add similar language to conform with USERRA. So nothing too distinct or different, but it does, bring it down to a state level to include terms and conditions or privileges of employment in this law. So action steps.
And again, you want to confirm that your policies and procedures are compliant, and you also want to make sure that you're training your managers on the rules for anti-discrimination. Again, this isn't too new. This is just kind of some clarifications, but you want to make sure that have gone through both of those steps to make sure that you're in compliance.
It's nice to have an easy one. A few more.
Yeah, exactly.
AB 260. This expands the existing human trafficking posting notice requirements, which currently it applies to certain types of businesses already to post a notice about human trafficking and assistance hotlines. Currently, that's airports, emergency rooms, alcohol retailers, and adult and sexual-oriented businesses. It's now expanded to include the same notice, similar notice for hotels, motels, and bed and breakfasts. It also requires new language in the notice to state that the person can actually text a specified number for services and support versus just an assistance hotline. So that's one. The second one, AB 1701, general contractor liability for wage payment claims. Basically, this says that a general contractor will now be responsible for any payments that are owed to a wage claimant by their subcontractors. So basically, if your subs don't pay their workers, the general direct contractor has to pay their workers. That includes wages, fringe or other benefits payments, interest owed, but it does not include penalties or liquidated damages. It just requires the general to step in and pay for the sub. The law also requires subs to provide payroll records to generals upon request. This law only applies to contracts entered into on or after January 1, not existing contracts or contracts entered before that date. And when this bill was signed into law, Governor Brown actually issued a memo saying that there's more to follow. So we need to keep our eyes open for any future revisions, because it was noted that there will be future revisions to this bill. So any action steps for this, Michael?
Really, the action step here is just to make sure you update your posting. And I didn't mention this before, but if you go on your client services website, there is an area where you can request postings for your company. So, it makes it fairly easy for you to be able to pull those out when they come available. So check out the client services website to be able to get that.
Great. So the last big topic, and we'll spend, kind of the bulk of the remainder of our time on this, is on SB 63, which is California Parental Leave Protection. This expands parental leave protections for those employers with at least 20 employees, 20 to 49 employees in the state of California. It's nicknamed the California Baby Bonding Leave Act. The new law, only to be clear though, just applies to childbirth and foster care and adoption, although it's very, very similar to the FMLA and CFRA. Just remember that this law, although it does sort of become the shrinking of the CFRA, it only applies to bonding with a new child or for adoption or foster care placement. It's the unpaid leave, similar to FMLA. It adds a job and benefit protection and anti-retaliation provisions. It's limited to employees who are not subject to FMLA or CFRA, and that seems confusing at first. Like, why would they even put that in there? The practical effect, obviously, it applies to employers with 20 to 49 employees within 75 miles radius. But if you have multiple locations throughout California that are beyond 75 miles, each one would stand alone. So that's why they mention that it's limited to employees who are not subject to FMLA. So even though it's, that distance might kick those smaller divisions into this protection. Obviously this was, there was a lot of fight against this one. They feel like this is really burdensome on small employers. So we do understand and appreciate that smaller employers, this will be difficult sometimes because of that job and benefit protection. If you only have 25 employees, it's really hard to be out a person in a smaller work environment. You have to keep their job open for 12 weeks. So that is the practical reality and what people are going to be struggling with as we get through this law. But that's the basic. It's very similar to FMLA, but applied to small employers with respect to childbirth bonding, including adoption and foster care. So eligible employers, we talked about this. It's, whether if you employ 20 or more employees to perform services for a wage or salary. In essence, it's similar to the FMLA concept, but all employees on payroll are counted. That's how you count it, all employees on payroll. So you could probably hit that number quickly. It essentially expands coverage to employers within that 75 miles. So again, that might be the distinguisher. If you have multiple work sites under the same employer and you're outside of that 75-mile radius, it's going to kick you under this law instead of FMLA. So more about eligible employees. They must have worked 12 months or more with the employer. Again, very conceptually similar to FMLA and the CFRA. They must have worked at least 1,250 hours in the previous 12-month period. Again, same eligibility requirement. Work at the worksite location, we talked about that. It's where there's at least 20 employees within a 75-mile radius, different than the 50 employees, but similar concept. It does not apply to employees, as we discussed, that would have otherwise been subject to FMLA, so it's its own freestanding law. The leave entitlement itself, it's 12 weeks of parental leave. This is in addition to the leave under PDL, under the pregnancy disability leave in California, which allows up to 4 months of PDL to employees working for an employer with 5 or more employees. So don't forget about PDL. It's qualified employees keep the same or equivalent job. Again, very similar to FMLA. Reinstatement may be denied if the leave was taken fraudulently, but obviously we would want to tread lightly on that before we'd make that determination. An employee may use their accrued vacation sick or other accrued PTO or other paid or unpaid time off as negotiated with the employer, but it cannot be required. You have to allow it, but it can't be required. More about the entitlement itself. Again, similar concept. Employees' benefits must be maintained under the same conditions as if the employee continued to work. That includes group health benefits and any other benefits according to company policy. You can't refuse to maintain and pay for coverage under that group health plan, obviously. Employees can continue to be responsible or are responsible for their portion of insurance premiums. Essentially, you can invoice the employee while they're out on leave. Should they fail to return from leave, the continuation, recurrence, or onset of a serious health condition or other circumstances beyond their control for reasons other than that, then you can go back and recoup the premiums as well. So again, if they don't pay you for your premiums, you could essentially, in some circumstances, go recoup it. And benefits must pick up where they left off if the employee stops them during leave. I'm going to stop on that to let you talk for a minute about Oasis's role cycle before I jump to the next one.
Yes. One of the things you can do is, we have a department that is, designed to help you manage through the leave process. Probably the best way to go about this is to get a hold of your relationship manager. If you have somebody, if you're not sure really what your practices should be, your relationship manager can help you walk you through that and help you understand. And then when it comes time to actually, okay, I've got a person, they need to go out on leave, we have a leave department, and they're designed to help and support you through, watching the number of days, when they should be returning, how their benefits operate. And, we are here to assist you through all that, because obviously this can be, fairly complicated when you've got, the multiple leaves with, FMLA, this new leave entitlement, CFRA, pregnancy disability leave. There's, lots and lots of leaves for California. So we are here to help you with that. So before you just, let somebody go out, make sure that you're contacting Oasis, going through our system and through our departments that will help you for that. And we can help guide and lead you through the process of getting people on leave and then getting them back to work.
Great. So more about the leave entitlement. If both parents work for the same employer, they're entitled to the leave. If they're both entitled to the leave, if the employer is not required to provide more than 12 weeks total, so that's good to know. Paid family leave wage benefits are available to both parents though too. So being mindful about how PFL also interplays as well as PDL. So as we mentioned, leave under this law is limited to just a specific parental leave. So having this note about them with two parents with the same employer does help a little bit. It's not much. An employer may, but is not required to grant both employees simultaneous leave. So again, in a small employer situation, it might not be feasible to allow them to have simultaneous leave. So you can, but you are not required to do that. And so more requirements and protections. The employer obviously can't deny leave. The employer cannot retaliate or discriminate against an employee for taking the leave. We can't interfere with employees' right to leave. As I mentioned in the beginning, this bill has had lots of objections and with respect to the burden on the small business. But these are the requirements and the protections. There is a mediation pilot program that's attached to it. So say it does get violated and an employee is going to sue over it, the parties can participate in mediation. But the reality is it doesn't take away the burden that it will impact on small employers. So they need to be ready for it. So on the employer's responsibility side, Michael, I'll turn over to you for that.
Right. So what you want to do, you want to make sure that you update your handbook to include new leave policy requirements. And so that includes, adding the particular new section that we were just talking about earlier, as well as, updating any of your older policies that may not have the requirements built in them appropriately. You want to make sure that those are all brought up to date. And then when an employee has a need for leave under this act, you can't require them to use their paid leave while on parental leave. And, we talked about that a little before. Lots of companies' policies usually have you use up everything that you have while you're on leave, and then you can be allowed to take the unpaid leave. This says, while, that's still possible, it's not something that you can require for people to do anymore.
Okay. Next slide for you.
Oh, next slide. I'm sorry, I didn't say next slide. Okay, so I see. I'm sorry. There was one more there. So you want to also contact. I was like, wait, I had the wrong page up there. You want to contact your Oasis relationship manager about this specific process, and that includes your employee application for the leave of absence, the employer leave and return form, and again, we already mentioned that we will be your leave administrator. We have a dedicated department that will, monitor the days and monitor the activities of people off leave and getting them back onto to your payroll once they return. So those are all areas where Oasis will continue to support you as you help your people manage through their leave process. You can also contact our service center. If your relationships manager is busy, or if you've got a very, very urgent need, to have somebody go out on the leave, you can contact our service center. They also can assist you with the process, as well as the relationship manager in our leave department.
Great.
Okay, next slide.
So the do's and don'ts, just as a practical matter, covered the action items that Michael just went through, but just, to think through it, because again, this is one that's going to impact a lot of our groups. And there's lots of open questions about it, but at the base level, you need to update your handbook. That's important. And remembering too, this is parental leave. This isn't the same as, FMLA, where it's all serious health conditions, or, it doesn't apply to, family members. This is parental leave. So remembering that and updating your handbook, providing that written notice of the guarantee to reinstatement before leave begins. We know that's a tough one, but employees need to know that, and we have to abide by it. You need to maintain the benefits while the employee is on leave. Coordinate with your relationship manager, your HR consultant, to make sure you're getting more information. And also to discuss further if you think fraud or abuse is suspected. That situation might come up, and there is some different language in the law that carves the employee out of that requirement. Another do that's not on this list, but it goes without saying, but remembering to coordinate the PDL, PFL in California. There's so many moving pieces when it comes to leave in California that you need to be complying with all of it. So really look to us to help you through that process so you understand it. Please don't discourage employees or deny the parental leave. The law is what it is, and we'll get more details and be able to work through it as it applies, but it does exist, and you don't want to be sued over it and find yourself facing other consequences. And obviously don't take adverse action then against an employee for taking the parental leave. The law is in the books and it applies. So to end on that too, though, there are really some very open items that people are very curious about, and there's no information as of now about the following. First would be intermittent leave. Is it allowed? What's required? What's not? It does not speak to that. It also doesn't there's no information about the requirement of the employee to provide notice of a need. How far in advance or what do they need to provide? It's not addressed. Nor has the state created any sample forms yet, so the designation or certification or rights and responsibilities under the PLA. So we will certainly keep monitoring this area, because we know it's going to impact our employers and employer groups and employees. Employees are going to want to know how this applies to them. But please understand, these are open areas. We all know it's an open area, and we are staying tuned. Michael, anything else you want to add to that?
Yeah, really just about the last piece. There may not be sample forms created by the state, but obviously, we're going to have our own internal processes that will allow employees to be able to take the leave. So even if because the state may be, weeks or months after this goes into effect before we get any validated forms from them. So we will have the proper documentation that you'll be able to fill out, and your employees will be able to fill out, so that you can stay in compliance.
Great. So that's the end of the substantive portion. Obviously, we're not taking live questions, but we'll leave the platform open for a few minutes if people want to type in their questions, so we make sure that we capture them. Certainly thank everybody for participating today. And again, we look forward to your questions. Michael, if there's anything you'd like to add, I think we're wrapping up.
I think I'm good, and appreciate everybody taking time out of their day to hear about these, really important processes for your company.
Thank you very much.
Thank you, Michael. Thank you, Leanne. I will leave the field open for just a little while so that people have the opportunity to type any additional questions in. And with that, I will let everybody go. Have a great day.
Thanks.
Thank you.